Mother-in-law sued me for the farmhouse 3 weeks after we buried her husband. The papers came on a Tuesday. I remember because I'd just finished rewiring the pump house, and my hands still smelled like copper and well water when I opened the envelope at the kitchen table. She wanted everything: the house, the 12 acres, the barn, the equipment, the orchard I'd spent 8 years bringing back from rot. Her lawyer's letter called me a person of opportunity who had exploited an aging man's diminished capacity. That was the phrase. I read it twice. Then I made coffee because I didn't know what else to do. My husband had been dead for 2 months. His father, 10 weeks. We had buried them in the same plot, back to back, like the universe had decided to clear the table at our house all at once. And now his mother, who hadn't set foot on the property in 6 years, wanted me out by the end of the season. I called my own lawyer that afternoon. Her name was Tess, and she'd handled my husband's estate, and she said the words people always say in those situations. We'll fight this. They don't have a case. You're on the deed. And I let her talk. I let her plan. I let her get angry on my behalf, because somebody had to, and I wasn't quite ready yet. But I already knew, sitting at that kitchen table with the smell of copper still on my hands, that I wasn't going to fight her the way Tess wanted me to. I was going to let her win. I want to back up, because none of this makes sense without the 8 years before. I'm 31. I married my husband when I was 23. He was older than me by 11 years, a soft-spoken man who taught middle school history, and came from a long line of Pennsylvania farmers who had quietly stopped farming sometime in the 1980s. His father, my father-in-law, had inherited the property in Lancaster County from his own father and had let it sit. He kept the lights on. He paid the property taxes when he remembered. He let the orchard go feral and the barn roof cave in over the tractor. And by the time I met him, the farmhouse smelled like mildew and the kind of grief that comes from watching something you love rot in slow motion. My father-in-law and my mother-in-law had divorced when my husband was 19. She moved to Scottsdale with a man named Roger who sold timeshares. She remarried, divorced again, remarried a 3rd time. By the time I came into the family, she lived in a stucco house in Arizona with central air and a pool. And she came back to Pennsylvania maybe once every 2 years for a funeral or a wedding. And she always stayed at the Marriott in town because the farmhouse, she said, wasn't habitable. She wasn't wrong. The first time my husband took me there, I was 22 and I stepped onto the porch, and a board went straight through under my heel. I remember laughing. I remember my father-in-law laughing too, this dry crackle of a laugh and saying, "Welcome to the Dunmore place. Watch your step." That was the name of the farmhouse. Dunmore, after his grandmother's family. My husband and I were renting an apartment in Lititz back then. He was teaching. I was working as a paralegal in a small firm that handled mostly real estate closings, and we had no money and a lot of free weekends. We started driving out to Dunmore on Saturdays to help his father with little things, patching the porch, cleaning out the kitchen. My father-in-law was a widower in spirit if not in fact, his wife 2,000 miles away with husband number 3, and he was lonely and he liked having us there. We'd bring sandwiches, we'd stay until dark. After about a year of this, my father-in-law sat us down at the kitchen table. The same kitchen table where I'd later open that lawsuit envelope, and he said, "I want to talk to you both about something." He told us he was 68 years old. He said his pension was thin. He said he'd spent the last decade watching this property fall apart, and he didn't have it in him to fix it, and he didn't have the money to fix it either. But he loved it. He'd grown up in this house. His mother had died in the upstairs bedroom. He didn't want to sell. He didn't want it to go to a developer who'd cut up the orchard for cul-de-sacs. He said, "I want to put it in your names, both of you, while I'm still alive. I'll stay on as a life tenant. You take care of it. You make it yours. When I'm gone, it's already yours, and there's no probate, no fighting," my husband cried. My father-in-law cried. I sat there, 23 years old, and I thought about my own father, who I hadn't spoken to in 4 years, and I thought, this man is giving me a home. We met with a lawyer in Lancaster the next week. Not Tess. This was earlier. A man named Kudahi, who'd been my father-in-law's attorney for 30 years. He drew up a deed transferring the property to my husband and me as tenants by the entirety, with my father-in-law retaining a life estate. Standard stuff. He also drew up a side document, recorded as a covenant running with the land that laid out the maintenance obligations, the taxes, the insurance, the structural upkeep, the agricultural use requirement because the property was enrolled in Pennsylvania's Clean and Green Tax Assessment Program. If the property fell out of agricultural use, the back taxes would come due, what they call a rollback tax. 7 years of deferred assessment, due in full with interest. I read every page. I was a paralegal. I'd read 1,000 deeds. I understood exactly what I was signing. My husband, who taught the French and Indian War to 12-year-olds, read it more carefully than I would have expected and asked good questions. My father-in-law signed everything with a fountain pen his grandfather had given him. I remember Kudahi saying, almost as an afterthought, now, this clean and green covenant, you'll want to keep that orchard producing, even just a little. It's the only thing keeping your assessment reasonable. I nodded. I had no idea what I was nodding to. I just knew the deed was now in our names, and that we owned a farmhouse, and that I was 23. The work started that spring. I don't want to make this part dramatic, because honestly, the work was just the work. We replaced the porch first, then the kitchen subfloor, which had a soft spot near the sink that turned out to be a 40-year-old leak, then the electrical, which was knob and tube in half the house and a fire waiting to happen. We did most of it ourselves, on weekends and summers, with my husband's hands and my stubbornness and YouTube videos, and a credit card we paid down slowly. We had a contractor for the roof and the septic, but everything else we did. By year 3, we'd moved in. My husband transferred to a school district closer to Dunmore. I left a paralegal job and started doing remote contract work for an estate planning firm in Philadelphia, which let me stay home and learn how to prune apple trees. There were 47 trees in the orchard when we got there. By year 5, I'd brought 30 of them back. The other 17 I cut down and replaced with new stock, heritage varieties, the kind you can get at a grocery store. Stamen wine sap. Smokehouse. A couple of Newtown pippins that my father-in-law remembered from his childhood. My father-in-law lived with us the whole time. He had his bedroom on the first floor. We'd converted the old parlor when his knees got bad. And he ate dinner with us every night and watched Phillies games and told me, over and over, about the way the orchard used to look in 1962. He was the closest thing to a father I'd had in a decade. He walked me through the property line in the snow one winter and showed me where his grandfather had buried a Civil War rifle, which we never dug up because what would we do with it? My mother-in-law came to visit twice in those 8 years. Once for my husband's 40th birthday. Once because her sister was dying and she came east for the funeral. Both times she stayed at the Marriott. Both times she walked through the house and made small comments. You painted this dark. That wallpaper was original. Your father always loved that ugly clock. She never asked who'd paid for the new roof. She never asked who'd done the kitchen. She drank 1 glass of wine at dinner and went back to her hotel. When my husband got sick, it was fast. He went to the doctor for what we thought was a kidney stone in January, and by March we had a diagnosis, and by May we were in palliative care, and by the 2nd week of June he was gone. He was 42. We didn't have children. We talked about it, and we'd waited, and then he was gone. My father-in-law lasted 6 more weeks. I don't think it was anything medical. I think his heart just stopped wanting to. He went to sleep one night in August and didn't wake up, and I found him in the morning when I brought his coffee. I buried them both. My mother-in-law flew in for the 2nd funeral and stayed at the Marriott and left the next morning. She hugged me at the graveside and said, "Thank you for taking care of him." She meant my father-in-law. She didn't say anything about my husband. I think that was the moment I knew something was coming, though I couldn't have told you what. The papers came 3 weeks later. Her lawyer was a man out of Philadelphia named Marvin Hallstrom. I looked him up that first night. He specialized in what his website called complex family asset recovery. His photo showed a man in his 60s with very white teeth. The complaint argued that my father-in-law had been suffering from undiagnosed cognitive decline at the time of the 2017 deed transfer, that I had used my position as a paralegal to manufacture the conveyance, and that the property rightfully belonged to my mother-in-law as the sole surviving heir under the laws of intestacy, which of course made no sense because there was no intestacy. The property had been transferred during my father-in-law's lifetime. It had never been part of his estate, but that wasn't really the argument. The argument was vibes. The argument was lonely old man, young woman, suspicious timing. The argument was that I'd be expensive to fight, and she'd be cheap to settle with. Tess told me all of this in her office in Lancaster. She was furious. She'd known my father-in-law. She knew the deed. She had a copy of Cudahy's file. Cudahy had died in 2021, but his firm had archived everything, and she had a sworn statement from his junior partner who'd been in the room when we signed. She said, "We will eat them alive. We will get sanctions. We will get her lawyer disciplined." I asked her how much it would cost to litigate. She said, "To win, probably 40 to 60,000. Maybe more if they appeal." I asked her how much it would cost to lose. To just give it to her. Tess looked at me like I'd asked her how much it would cost to set myself on fire. She said, "Don't even joke." I went home that night, and I sat on the porch I'd rebuilt with my husband when I was 24, and I watched the sun go down over the orchard, and I thought about my mother-in-law in her stucco house in Scottsdale with her central air and her pool, and I thought about the Stayman wine subs coming in heavy this year, and I thought about the clean and green rollback. I want to be careful here, because I've told this story to a few people, and they always think this is the part where I got vengeful, and that's not how it felt. I wasn't angry. I was tired. I was 31 years old, and I had just buried my husband and his father back to back, and I didn't have it in me to spend the next 2 years in court being called a manipulator by a man with white teeth from Philadelphia. I just didn't. And so I started doing the math. The clean and green rollback tax in Lancaster County on 12 acres of orchard classified land that had been enrolled in the program since 1978 was, I had Tess's office pull the numbers, approximately $140,000 plus statutory interest, due within 60 days of any change in ownership or any cessation of qualifying agricultural use. The trigger was clear in the deed covenant. A change in ownership where the new owner did not continue agricultural use was an immediate accelerator. The roof I had put on in 2019 was a 30-year roof, but the warranty was non-transferable and the manufacturer required annual inspections by a certified contractor at roughly $1,200 a year to maintain coverage. I had those records. The septic system, which we had replaced in 2020, required a state-certified pumping and inspection every 2 years to remain compliant with the township's on-lot disposal ordinance, with a current cost of approximately $800 per service. Plus mandatory dye testing if ownership transferred. That was another $2,200. The well had to be tested annually for coliform and nitrates under our township code. The orchard pesticide management plan, which I'd registered with the state because 3 of my heritage varieties specific spray windows, was a license held in my name personally, non-transferable, and without it, the orchard couldn't legally be sprayed, which meant within 2 seasons the trees would be unsaleable and would default the clean and green status. I started listing everything. The propane contract that auto-renewed and required a $1,500 tank rental annually because we'd never bought the tank. The historic preservation easement my husband and I had signed in 2020 in exchange for a small state grant. That easement required any structural exterior changes to be reviewed by the County Historical Commission, with fees, and required the owner to maintain the original 1847 facade indefinitely, with documented annual maintenance. The deed restriction prohibited subdivision until 2047. The conservation easement on the back 6 acres, granted in exchange for a 2019 tax credit, prohibited any non-agricultural development in perpetuity. I was sitting at the kitchen table at 1 in the morning with a yellow legal pad and a calculator, and I realized something. The property wasn't an asset. Not in the way my mother-in-law thought it was. The property was a job. It was a job I had been doing, full-time and unpaid, for 8 years, and the moment I stopped doing it, the bills would come due all at once, not in some abstract way. In a $140,000 in 60 days way. I didn't tell Tess my plan. Not at first. I just told her I wanted to settle. I told her I'd been thinking about it, and that I didn't have the heart for a fight, and that maybe my mother-in-law deserved the chance to live in the family home. Tess argued with me for 2 weeks. She told me I was making a grief decision. She told me I'd regret it. She said, "Let me at least file a counterclaim for the value of your improvements. You put $250,000 of work into that property. At minimum, get reimbursed." I said no. I said I didn't want her money. I said I didn't want her money. I said I didn't want anything from her. I think that's the part Tess understood least, but it was the truth. I didn't want my mother-in-law's money. I wanted to be done. I wanted her to be done. I wanted her to be done. I wanted the lawsuit to disappear, and I wanted to walk away clean. What I did do quietly was call the Lancaster County Tax Assessor's office and confirm the clean and green rollback calculation. I called the State Forestry Office and confirmed that the pesticide license was non-transferable. I called the Historical Commission and got a written estimate of the deferred maintenance they would require, an inspection to assess upon ownership change. I called the Conservation District. I called the Township Zoning Officer. I made sure that everything I'd be handing over was current, compliant, and documented, and that the moment she signed her name, every single obligation would transfer with the deed. I also did one more thing. I called Cudahy's old firm, and I asked them to send me a certified copy of the original deed covenant, the maintenance schedule, the agricultural use requirement, the rollback triggers, the easement obligations. The full document, the one that my father-in-law had signed in 2017, that ran with the land, that bound every subsequent owner. Then I called Tess and told her I wanted to accept the settlement on one condition, that my mother-in-law's lawyer acknowledge, in writing, receipt of the complete chain of title documents, including the recorded covenant. Tess thought it was strange, but she said it was harmless. They'd want those documents anyway for due diligence. Hallstrom's office accepted within 48 hours. They were thrilled. I imagine they thought I'd cracked under pressure. The settlement agreement was simple. I would execute a quitclaim deed, transferring my entire interest in the property to my mother-in-law in exchange for a full release of all claims, and we'd be done. We scheduled the signing for a Thursday morning in October at Hallstrom's office in Philadelphia. My mother-in-law flew in the night before. She stayed at a hotel near Rittenhouse Square this time. Tess drove me down. I wore a black dress because I didn't have any other clothes I wanted to wear that day. Hallstrom's office was on the 18th floor of a building on Market Street, and it had the kind of lobby that's designed to make you feel small. My mother-in-law was already there when we arrived. She was wearing a cream-colored suit and pearls, and she stood up when I walked in and tried to hug me, and I let her, because what else was I going to do? We sat at a conference table. Hallstrom had a junior associate with him, a woman in her late 20s who looked tired. Tess and I sat on one side. They sat on the other. Hallstrom slid the settlement agreement across the table, and I read it again, and I signed it. He slid the quitclaim deed across. I signed that too. I notarized everything. I handed my mother-in-law the keys to the farmhouse. 2 keys, on a brass ring my father-in-law had owned since the 70s. Hallstrom looked very pleased. He said, "I trust we can all consider this matter closed." Tess said, "We'd like the written acknowledgement of the covenant documents we sent over." Hallstrom waved his hand. He said something like, of course, my associate has reviewed them. The associate nodded without looking up. Tess pushed the form across. We'd like it signed. Hallstrom signed it, stamped it, slid it back. The associate, I noticed, looked at the form a little longer than he did. She was reading the cover sheet, which listed every document by name. The deed, the original covenant, the clean and green enrollment, the conservation easement, the historic preservation easement, the pesticide management plan, the septic certification, the roof warranty terms, 11 documents in total. I watched her face change. It was very small. She didn't say anything. She just stopped nodding. She turned to her stack of documents and started flipping through slowly and then less slowly. She got to the covenant. I knew exactly when she got to the covenant because her jaw set. Then she got to the clean and green enrollment certificate and she went still. Then she pulled out a calculator on her phone. My mother-in-law was talking. She was telling me she hoped there were no hard feelings, that family was family, that she planned to spend the winter in Arizona and come east in the spring and see what needs to be done. She was holding the keys in her lap like a trophy. The associate leaned over and whispered something to Hallstrom. He frowned. He didn't really hear her at first. She whispered again, more insistently, and pointed at the covenant. He took it from her. He read it. I watched him read it. I watched his face do exactly what mine had done at 1 a.m. at my kitchen table 6 weeks before. I watched him reach the section about the rollback tax, and I watched him reach the section about the pesticide license, and I watched him reach the conservation easement schedule, and I watched the color leave his face. He looked up at me. He didn't say anything for a long moment. Then he said, very carefully, "Mrs. Hallstrom, can I speak to you in the hall for a moment?" He'd called my mother-in-law by his own name. He didn't even realize it. She looked confused. She said, "We're done, aren't we?" He said, "We're done, auntie," he said. "We just need to clarify something." She got up and followed him into the hall, still holding the keys. The door closed. Tess looked at me. She said very quietly, "What did you do?" I said, "I didn't do anything. I gave her what she asked for." We could hear voices through the door, not the words, just the pitch. His was low and steady, and his was the pitch of a lawyer realizing he has just walked his client off a cliff. Hers got higher and higher. At one point I heard her say, "Clearly, what do you mean 140,000? They were in the hall for 22 minutes. I know because I watched the clock on the wall. The associate stayed at the table with us and didn't say anything. She was looking at her hands. When they came back in, my mother-in-law's face was the color of old paper." Hallstrom said, "We're going to need to discuss some matters with our client privately. Could we reconvene next week?" Tess said, "The settlement is executed. The quitclaim is signed and notarized. Those are filed today." Hallstrom said, "We may need to seek a modification." Tess said, "On what grounds?" He didn't answer. I want to be clear about what happened next, because this is the part where I think people expect me to have enjoyed it, and I didn't. I didn't enjoy any of it. We filed the deed that afternoon. The transfer became official. The clean and green rollback tax notice was generated automatically by the county system within 10 business days. It went to my mother-in-law's Arizona address because that was the address now on file. $143,218, payable within 60 days. The Historic Preservation Commission sent her their standard new owner inspection notice. The Conservation District sent her the easement compliance schedule. The State Forestry Office sent her a letter informing her that the pesticide management license attached to the property was non-transferable and that any application of restricted-use pesticides without a new licensed applicator would be a violation of Pennsylvania law. The propane company called her about the tank rental contract. The septic inspector left a card on the door of the farmhouse. The door I had refinished myself, sanded down to the original 1847 oak, informing her that a transfer-triggered dye test was required within 30 days. She called me about 3 weeks in. I let it go to voicemail. She left a long message. She was crying. She said she didn't understand any of this. She said her lawyer had told her the property was free and clear. She said she couldn't afford any of it. She said, couldn't I please come back and help her sort it out? I called her back the next day. I was kind. I want you to know that I was kind. I told her I was sorry that her lawyer hadn't explained the obligations to her. I told her that everything she'd received in the mail was accurate. I told her that I would be happy to give her the name of a good agricultural property attorney in Lancaster who could walk her through her options. I gave her 3 names. She said, can't you just take it back? I said, I can't. I claimed it. It's yours. She said, but I don't want it like this. I said, I know. I'm sorry. She sold it 5 months later. To a developer, of course. The orchard came out. The farmhouse, I heard, is still standing. There's a covenant on the facade that prevented its demolition. But it sits at the edge of a cul-de-sac now with 12 houses around it where my husband and I used to walk in the snow. She got, I'm told, about $320,000 for the sale, after the rollback tax and the easement violation penalties and her legal fees. She would have gotten more than twice that if she'd kept the orchard running for another 2 years. I want to say something now that I've thought about a lot. The lesson in all of this, the one I've come back to over and over, isn't that I won. I didn't win. My husband is still dead. My father-in-law is still dead. The orchard is gone. The Stamen wine saps and the smokehouse and the 2 Newtown pippins my father-in-law remembered from his childhood are gone, root and branch. I drive past that cul-de-sac sometimes when I'm in Lancaster, and I don't feel triumphant. I feel like someone who watched something she loved get taken apart by people who didn't understand what they were taking apart. But I also didn't lose. Not in the way she meant for me to lose. What I learned, and I think this is the real thing, the thing my father-in-law would have wanted me to know, is that ownership isn't what people think it is. Ownership isn't a trophy. Ownership isn't a flag you plant. Ownership isn't the daily, expensive, exhausting work of keeping something alive. The deed is just the paperwork. The actual ownership is the 8 years of pruning and rewiring and septic certifications and pesticide licenses and the soft spot near the kitchen sink that you finally figured out how to fix. Anyone can sign a piece of paper. Almost nobody can do the work. My mother-in-law wanted the trophy. She thought she was taking something from me. She didn't realize she was being handed a bill. I bought a small house in Lititz with what was left of my husband's life insurance and the money I made selling our equipment. I have a small backyard. I have 4 apple trees, 2 stamens, a smokehouse, and 1 Newtown pippin that I grafted myself from cuttings I took the week before the closing. They're 4 years old now. They're starting to produce. I still talk to Tess sometimes. She forgave me eventually. She said once over coffee, I'll never understand why you didn't fight her. I told her I did fight her. I just let her win the part that didn't matter, so she'd take her hands off the part that did. I don't know if that's the right way to live. I don't know if that's the right way to live. I don't know if I'd do it again. But I sleep at night. I keep the trees alive. And every fall, when the first stamen comes in, I cut it in quarters at my kitchen table, and I think about the man who taught me how to prune, and the man I married, and the kind of inheritance that nobody can sue you for. That's the only kind that ever really transfers. I think about that signing room sometimes. The 18th floor, the cream-colored suit, the pearls, the way my mother-in-law's hand closed around those 2 brass keys like she'd finally caught something she'd been chasing her whole life. And I think about the look on Hallstrom's face when his junior associates slid that covenant across the table, and the silence that followed, and the 22 minutes they spent in the hallway while the rest of us watched the clock. I didn't plan that moment to hurt her. I want to be honest about that, because the easy version of this story is that I outsmarted her, and the truth is closer to, I refused to fight her on her terms, and I let the ground do what the ground was always going to do. The covenant existed in 2017. The rollback tax existed in 2017. The conservation easement, the pesticide license, the propane tank, the historic preservation rules. All of it was already there, sitting in a folder in Kutahi's old office, waiting for anyone who cared enough to read it. I just made sure she received the folder. Tess called that a strategy. I called it telling the truth. What I keep coming back to is the difference between wanting a thing and being willing to do the work a thing requires. My mother-in-law wanted the farmhouse the way people want a photograph of themselves at a place they've never lived. My father-in-law had wanted it the way you want a person you've loved for 60 years, every morning, even the bad ones. Those are different wants. The deed doesn't know the difference. The land does. I learned something in those 8 years of pruning and rewiring and septic certifications that nobody told me when I was 23. Character is not what you say at the kitchen table. Character is the soft spot near the sink that you keep going back to fix. It's the annual colophon test you remember to schedule. It's the night you stay up past midnight reading a covenant because you'd rather know what you owe than be surprised by it. My father-in-law had that. My husband had that. I learned it from them, and I'm not sure I would have learned it anywhere else. The harder lesson, the one I'm still working on, is that you don't have to punish the people who try to take from you. You just have to refuse to lie about what you're handing over. My mother-in-law signed her name to a document she didn't read, advised by a lawyer who didn't read it for her, and the bill came due. That wasn't my doing. That was hers, and his, and the predictable shape of the world when people mistake ownership for entitlement. I keep 4 trees in my backyard now. I prune them in February. I spray them in May. I pick them in September. Nobody is going to sue me for them. Nobody is going to want them enough to. And every fall, when the first stamen comes off the branch, I cut it into quarters. And I remember that the only inheritance that matters is the kind that travels in your hands.